Good evening and welcome to Legal Tech Live. I'm your host, Nick Rishwain, and I'm here tonight with my guest, Sophie Walker. Sophie is the CEO and founder of Just Transcription. Sophie works as a barrister, and she uses her frontline experience to fight for changes that will make a difference. Now, I think it was late last year. No, it's maybe 2019. We had done quite a few. I tried to do one access to justice interview a month. And we did that in 2019, but it's been a while. We've focused more on just standard legal tech in the last year and this year. But Sophie has agreed. She is part of our Female Founder series, which has taken up all of August and September, which is really nice. We were able to fill it up with like 8 or 9 straight female founder interviews. And thank you, Sophie, for being here. You are a barrister. You are an access to justice advocate. Welcome to Legal Tech Live. And
thank you very much. I'm hugely honored to be here. And this is what I look like at 2:02 a.m. And given that I'm 36, I'm kind of into it. Actually.
Yeah, no, it looks good. You look great. You look great. You sound great. So
let's start with the
good.
Important things. Exactly.
Yep. Tell us how you came to. So you're working as an attorney. Tell us a little bit about your journey into the practice of law, and then how you started going into the more technology side of things to try and improve access to justice services.
Sure. Let's. I actually thought to start with a quick pop quiz.
Oh, so, are you quiz? Wait, am I on the other end now?
Yeah, you are.
Yeah.
Hold on tight. So my journey in legal tech. I started while I was working as a lawyer in a city in the US.
Okay.
And this city has a slogan. And the slogan is the cradle of the Confederacy, the birthplace of civil rights. Name the city.
Selma?
Selma? Well, close enough. It's Montgomery.
Montgomery. Okay.
Yeah. So
I mean, could only think of Alabama for that, but you really got me on that one. Are there going to be a lot of other pop quizzes? Because I don't know.
No, that's it. That's just. I just thought I'd give you a tough start, so at least we're both on the same level playing field.
I appreciate that. But I don't think I can get that close on a second question. So
in 2007, I got a job working with Brian Stevenson of the Equal Justice Initiative down in Montgomery, Alabama. And it was a staff attorney position funded by NYU, where I'd done my master's, went to uni over here, went to NYU for my LLM. And as happens to most NYU law students, took a class with Brian Stevenson, and the rest is history, right?
Right. Would be pretty inspiring.
It's pretty inspiring. That guy changed his lives. And I was 22, and all I wanted to do was move to Alabama and work on death row, and that was what I was lucky enough to do.
That's awesome.
And it was, my first bar exam, I qualified in Alabama, which was pretty interesting experience. I had to qualify because I was UK educated. I had to go to the Alabama Board of Good Character before I was allowed to sit the exam.
Oh wow!
And they ushered me in, and they said, "Now, Miss, I'm not going to do the Southern accent, but imagination time, guys, right?
Right.
So, all right, Miss Walker, we've looked at those UK laws, and they're very different to our laws of Alabama. We don't think we feel comfortable with any of this. Tell us, are you going to marry a nice Alabama boy?" And
how's this relevant?
I just don't think this is what is meant to be happening here.
Right.
Anyway, despite by that point being a true blue lesbian, I crossed my fingers behind my back and I said, "Sir, absolutely, I am looking for my Alabama boy."
So,
anyway,
which is such a testament to the character, right?
I think apparently what it takes. So I then practiced in Alabama, and when we were working on death penalty cases and doing appeals, you would hear your case before you would see it, and it would come down the corridors in a trolley in transcript bundles of being 200 pages per bundle. And it was every single word that was uttered on that case. So from the moment the case was opened till the moment he was, the person was sent down at the end of the sentencing hearing, every word was transcribed. And that was your foundation for the appeal.
Wow.
And that was it was my first job straight out of law school. That is how I understood it as an appellate lawyer. You prepared, your starting point was the transcript, which had every word included.
And that's all you could work from.
And that's what you would work for the first stage of the appeal. That's what
first stage. Okay.
First stage. Then we go on to habeas. Obviously, that's more. But that is a foundational document. That's what I was trained of. So I spent 2 years at EJI, another 3 years doing death penalty defence, and then sort of moved back to the UK and started working here. And in the UK, I started working on criminal appeals, kept doing criminal appeals cases, first as a solicitor. And each time I was looking for that transcript. And the first time I called up the Old Bailey, which is the most sort of senior and famous court in the UK.
Mm-hmm.
And I said, I'm looking for a trial transcript. And they were like, well, they said, well, when was the trial? How long did it take? And I was like, so these are the details. It was 3 weeks. Yes, I want everything. Yes, really, no, I really mean everything. How much will that be? And they were like, that'll be £25,000.
Whoa. And how many pages were we talking?
Well, we were talking a lot. It
was a lot of data.
This is 3 weeks. But that is, that is a lot of money. Now that is beyond what my clients had to pay. It was beyond what I could get public funding for. Mm-hmm. And so there was this sort of moment in my head when I was like, what is going on? The cost, the sort of foundational documents that you need to appeal the case are beyond the reach of the vast majority of litigants in court. Mm-hmm. And yet this is their own information. This was their own trial.
Right.
Why is this so expensive? And I looked and I was like, look, the technology that is in my phone, speech to text technology, this is ubiquitous, straightforward, run-of-the-mill technology that is in my phone.
And by speech to text, just for our audience and listeners, you're comparable to Siri or something to that effect, right?
Exactly. Or when you if you transcribe into your phone, or they now have it in Word. So this is the sort of speech text or voice recognition technology,
right?
It's everywhere. And even back in 2016, when I was thinking about this, it was everywhere. So I said, gosh, if we could just plug this technology into the courtroom, it could change everything. That was my light bulb moment. And I was like, I could then get to the point where I was in good old Montgomery, Alabama, with my transcripts, preparing for my appeal, paying a fraction of the $20,000, $25,000 I'm expected to pay for this now.
Because you could get it transferred to you digitally, I imagine, right? Or cloud-based.
Digitally, you could get it automatically transcribed, and then you could use that transcript as a guide, right? Like speech to text, we'll talk about this in a moment in terms of accuracy, but this was my sort of kernel of my idea. Okay. And ordinarily, if I, as a lawyer, if I run into a challenge like that, my first thought is, who can I sue to get this?
Sure.
Right? Who's standing in my way?
Who's responsible?
Right. Who's responsible, and how how can I sue them to get what I want? That's right. My process. And for the first time, I was like, this isn't a litigation problem. This actually isn't really a technology problem. This is a cultural change problem. Mm. And the way that you bring about change is one of the things I sort of learned from Brian Stevenson and the others I've worked along the way, is that you need to make the ground that with the person who is opposing you, you need to take away all the reasons they have to say no. And once you've done that, once you've dismantled the ground they stand on, they have to agree with you.
Which is an interesting approach. It's a different approach than the adversarial nature that it's more of a chipping away rather than a battling head to head.
Definitely. Yeah.
Interesting.
And it's about sort of how do you bring about system change? And I was like, if I'm able to launch a product that people could that will allow both sort of lawmakers and litigators and judges to see that this is that this tool could really make a difference to the way that they practice, that it can make their lives easier, that it is not complicated, that technology is safe and secure and usable, then we will gradually begin to see this shift away from these old-fashioned manual ways of working, of typists, of couriers, of audio being put onto CDs, into tapes,
The deforestation caused by legal in others.
And and I think this is an issue. I think it's in the States too. I was going back over some Twitter exchanges I've had with US attorneys over the last few years, and I got there was one that I reread recently. An attorney said that it would cost $7,000 for a trial transcript for her appellate clients.
Wow.
And often her appellate clients are choosing, do they get an expert evidence or do they get the trial transcripts?
Yeah.
Because that's their budget.
That's the budget. And I actually work in the daytime. One of our sponsors, experts.com, I work with the expert witnesses. I market there. And just today getting that, we need to request funds to hire an expert inquiry, right? And that's generally for an indigent client, an attorney has to request funds for that. And it's usually nowhere near as lucrative as working in a civil litigation. So you're working in $5,000, $6,000, and you can only get so much expert work for that.
Exactly.
So it's already pretty limited.
Yeah. So that's what I think. That's my idea, is that this is not complicated. This is not complicated technology, which does make it slightly tricky when pitching for VC, for investment, which we've been going through rounds at the moment, when you're saying, yes, I agree. Speech to text technology is not the complicated bit, right? Like what we want to do with it is interesting. The technology itself is not the sexy bit. And it's an interesting sort of balance, right? It cuts both ways.
And I want to get to that. I do want to get to that aspect about fundraising for access to justice, which is not also the sexiest, right? Because they don't see it as that rocket ship up into the right type of growth. But I don't know if I want to get there yet. I want you to tell me a little bit more about actually what Just Transcription does. So how does your service currently work?
So what we've launched is we have our transcription platform, and we've been doing direct client work for the last year and a half, and you can load up the audio. We accept video and audio files. And our sort of AI tool, which we have tuned for the legal and the justice sector, we think we're the only transcription tool that has accomplished that. Okay. So that we take the audio, we turn it into text. Mm-hmm. And what we've then done is we've created this editing tool that makes it really easy to edit that document for accuracy. And our clients then choose, do they want to do that work, the editing work themselves? Alternatively, we have a cadre of law students who we find are perfect for this job because they are anal. Mm-hmm. So we have these great law students who would then go and edit this document for you. So that's the service that we have. And we work a lot with data protection officers. Of course, we're all obsessed with GDPR. So there's that sort of strand to our work where working with doing some complaints for call centers and that sort of regulatory security work.
Right.
And what we're also we also work within the research sector. So for researchers and law students who have perhaps done interviews, so we can transcribe those for them. We do captioning and videos, and we do live events. So that's the work that we're doing essentially to improve our own software.
Okay. So
while we're doing the work of while we're doing those sort of editing work or transcription work for our customers, we're at the same time improving our software.
Excellent.
And what we start. Sorry, Nick.
And so I'm a barrister, or I'm an attorney, and do I have the transcript already? I must have to have that file, right? And where in the UK, you said getting this file is going to cost £25,000, which is significant. Are those files now digital and they can get a copy of that easier?
Well, I mean, that is a bit more of a complicated story.
Okay.
So this is I've spent But I started off just in sort of 2016, rather embarrassingly. I'm always very impressed with all the companies who've accomplished. You know, they've already bloody IPO'd by the time that we were just finishing our research phase. You know,
Some,
yeah,
that's
everyone's
okay.
on their own trajectory. You know, it's not a race. So I spent about 2 years learning everything I could about the workflow and the information flow of how, from the moment a word is uttered into a court till the moment it ends up written either on a legal database or
That
another.
whole workflow
That
process.
whole workflow. I was like, I want to make sure that whenever I go into a room, I know the most.
Right.
And so I spent all this time speaking to everyone in this workflow so that I knew all the possible permeations so I could work out where I wanted to plug my machine in.
Okay.
And how it could have the most impact.
Excellent.
And
where was that?
The thing that I worked out is that in most courtrooms, there is, in the UK, there is a specific computer. And the sole thing that computer does is record audio, which is an intriguing in and of itself, that that's what this computer does. And it records them onto CDs.
Okay.
And the audio is turned on in the morning and turned off in the afternoon. So you've already spotted one problem there. You know, in the criminal courts, you could have 20, 30, 40 cases in a day.
Right. So identifying which one you do the transcript for.
Yeah.
And I should probably take that back a second for our younger audience members. A CD is a circular device that at one time we stored information on, but you couldn't really store all that much compared to, say, what your phone can store today. And I do want to say hi to Johan, Karen, Mo Lilienthal's over in the Facebook group, as well as Ashley Pepitone. Thank you all for being here. If you have questions for our guest tonight is Sophie Walker of Just Transcription. So sorry, but I did feel like some younger attorneys are going to be like, on a CD, yeah. What do you mean? Like,
I do
not doing this in a cloud?
But I'm discussing this sometimes. I'm like, you know, there's still issues with tape. So then I'm like, tape is this little, it has this thing called actual tape. Tape has a tape. But, you know, these are the sorts of, and I'm sure that the same as the issue is still in the US courts, is they're using all this technology. And then COVID happened. Right. Mm-hmm. So when COVID happened, there was a big shift to remote hearings, online hearings. And during those hearings, the audio is saved up into an S3 bucket. And this was the sort of moment of truth for Just when it happened, and when I sort of worked out where the audio was being stored for this video hearings, I actually stopped and called almost everyone I'd spoken to since 2016. And I was like, this is our moment. Like, this is our moment. Because now I can go and plug my transcription machine into an S3 bucket, no problems. Right. Very
right.
The main problem that we had was never where the technology went. It was actually getting access to the audio.
Okay.
And now it is kept in a digital form for remote hearings, at least, which is a majority that's still happening over in the UK.
Mm-hmm.
But it's now in a digital form on the cloud, and that changes everything.
That changes everything.
So
when an attorney is now choosing between their $7,000, they've got $7,000 to pay for an expert or the transcript,
well, no, look, this is the theory. We've still got to persuade. We're still in the process of persuading judges and Ministry of Justice and everyone else that this is still something we should be allowed to do. We're beginning to have those conversations are progressing much easier now that technology has that we've overcome that step with the computers and the CDs and the couriers. But that's now much more possible.
That is much more possible. So let me ask this as kind of it'll be sort of two-part. So if I am a lawyer who has a transcript,
back to my pop quiz, Nick.
Yes. Right.
I have a two-part question.
Well, it's sort of the question is really who's your target market, but as far as product market fit. So I'm assuming right now, if I'm a lawyer, maybe with a civil case, that money's not an issue and I have the digital file, I can come and use Just Transcription, right?
Yeah.
And I pay for that as the lawyer. or my client pays for it as the
Yeah.
cost.
Or yeah, exactly. There's an array of transcription companies. In the UK, where there's limitations as to who can do court transcription because there's a government framework, there's a government contract, but all of that boring stuff. But the average cost of court transcripts is around £120 per audio hour.
Okay. All right.
So that's still pretty stiff, right?
Right.
Whereas,
that's pretty heavy.
yeah, it's pretty heavy. Whereas for our edited services, we currently come in at about 75-ish per audio hour. So we aim to be about 30% lower than the industry average. And as our AI tool improves, we aim to sort of pass on those savings back to the customer.
Okay. All right. So that's good. So is the customer, I guess, is your target customer, is my follow-up to that. Is it really the courts? Are you looking to get the government contracts more than you are to sell this to individual practitioners?
Well, I think that's a good question. Like ultimately, that's where in order to perform court transcription, it is often a government service, so you do need to be on the right frameworks. So we can either do that directly through contracting ourselves or by going to incumbents and working with them on a sort of digital transformation to move away from solely using manual transcribers and start incorporating speech text. And that's been the go-to-market strategy that we've been working on.
Okay,
so it's more of a partner route.
Route.
Yeah.
With the actual intermediary, the court intermediary, I guess.
Exactly. Yeah. Okay. Exactly. I think that's because at the end of the day, we see ourselves first and foremost as a software company.
Right.
So we want to build technology. We have our editing services, in part because it helps to improve our software.
Excellent. Ashley Pepitone is a Georgia lawyer and a friend of the show, and she says this is very awesome. I just started doing appellate work, and transcripts are so crazy expensive, prohibitively so for a lot of litigants, especially in family law. So and I've never had any appellate experience. It's untrue. I was intern at the appellate court in California. I did do that after my first year of law school. So, but that is the extent. I never actually did any of the process.
You wouldn't wade into appellate Twitter.
I don't spend a lot of time on appellate Twitter, but I've been telling Ashley that she should be on Twitter for like 2 years now. So, but that is very interesting feedback for you right there.
Yeah,
I was unaware that this situation existed, but I was playing through the financially speaking, who do you really target? Because as you mentioned, there's a lot of transcription services out there, and that's all right. So are we just doing it? No, we're trying to offer something where it's actually happening when it's being recorded.
Exactly. And I think this is, we've got no delusions about this sort of being a crowded market. We sort of try to differentiate ourselves in a number of ways. Like I think the legal transcription market has been a lot slower to embrace innovation compared to other areas. So while you see things like Otter AI and others, who obviously other trusted transcription engines, they seem to have stayed clear of the legal and justice sector. And indeed, one of the reasons why I started trying to develop our own software is that when I tried to use Otter, I wouldn't have trusted them with my legal data. I didn't think that their terms and conditions sort of stood up, particularly for the European market, where we have to be extremely careful.
Yeah, very careful.
With sensitive data. So that's our first, is that we're very we're honed for the legal and justice sector. We think we're the only transcription tool that is. We take security as paramount. We're not messing around. It's that informs every decision that we make. And then the third part is that we're a social enterprise. Now, when I set up Just, I had always worked in charities, right? I spent 10 years working in the third sector. It never occurred to me that I could set up an organization that wasn't somehow a charity or a social enterprise. Not that I realized the difficulty that I was going to be coming down the line when it comes to sort of how expensive technology is to build, and indeed what people would look at me when I said, yeah, we're a social enterprise, and they're like, well, and now you want my money.
Right. I was going to say, is that, how does that, I mean, normally I think the term in the US is impact company, right? Or
That's
and
exactly. Yep.
and
Yep.
and, my
Or B
understanding
Corps.
from
I think B Corps have more traction in the States. We don't have
or public benefit, public benefit corporations. But my understanding from my friends in the Bay Area who spend time is they love to talk, the VCs love to talk about, oh, we love impact companies, but then the checks don't get cut very much for them.
Yeah, I think that's
they like to
definitely
signal it, but so how are you approaching that?
That's definitely been my experience. Like, I think I have been lucky that the chair of my board is solely invests in impact-led
Oh,
companies. And so he has been a great champion, has also encouraged me to stick to what I want to achieve. And our sort of big, hairy goal, our self-driving car equivalent for Just Access, is still let's try and plug a speech-to-text engine into the courtroom, because that is the cheapest and the easiest and the most efficient way of getting access to the information. And that remains our lodestar. And that is hard, and we need to be a social enterprise, I think, in order to achieve that goal.
Because it's really a public-private partnership, right?
That's it. Because what happens in court is a public good.
Right.
It is public information. And if you are working in the field, I feel it's very strongly, as you can tell, if you're working in the field of public information, then you handle that with care. You hold that on trust of the public. And therefore, as a company, you need to run in accordance with those principles. So it would not ever be something I could do. It would not sit right to me to think that we could go and create a huge amount of sort of commercial gain from what's ultimately people's day in court.
Yeah, interesting.
If we're doing something with people's day in court, we need to handle that with care, and that come with sort of social and ethical responsibilities. And if that's what we want to achieve, that's how we need to govern ourselves.
Okay, I like that.
Yeah.
How does this impact? You said that COVID, and strangely, it's funny. I see the stories going around about LegalTech and COVID, and did it? Was it a turning point? And I mean, I think in certain respects, yes, on adoption of certain technologies, it was certainly a catalyst.
Look at e-signatures, right?
Yeah, e-signatures, certainly video like we're doing now was like it's been around for 20 years, and then courts started using it.
Yeah.
But you had mentioned that the video, which is recording audio, is helpful. What about inside the court? How does this affect something like a court reporter, or are those used less in the UK than?
So just to make sure we're speaking about the same thing, so there are court reporters who we consider, which essentially form a sort of legal journalists who report on cases, and then there are stenographers.
Stenographers is what I would call a court reporter.
Okay, so so we would call that a stenographer.
Okay.
There's very few that remain in UK courts.
Okay.
Sort of specialist service. So I think if you are a fancy pants law firm, then fancy pants law firm versus fancy pants law firm, then you can split the cost of a stenographer.
Okay.
But it's a nice to have. All other transcripts are done sort of after the hearing. So recording is taken. So
there's a recording already. It's just now these recordings are in the cloud finally.
And one of the question you asked before was sort of who is your target market?
Yeah.
But obviously we talked about courts and we talked about court transcription companies, but actually the other target market is legal information providers.
Okay.
So if we think about the databases, we're thinking LexisNexis, Westlaw, etc. They are entirely filled with judgments. Right? They have the only transcripts they offer are where a judge has spoken their judgment in court and it's been written down after the event.
Right.
There is almost no content which is transcripts of hearings. And
that's true. It's all, case law or statutory.
Right,
yeah.
because of course we live in a common law jurisdiction, so that's what's binding. But actually,
Right.
when we're reading cases, we're not just looking at what's the authoritative case. We want to know what the judge has decided before. How do they think about this issue? How did this other lawyer approach this point that I now want to argue?
Right.
And doing that from a judgment, you're always getting a skew because it's always from the judge's perspective.
Right. Right.
And so what we've been exploring over the last year or so, we received a government grant to do this, is what content from legal hearings would people find valuable? And so we did this round of user testing, and you can read every single possible framework about product market fit, but actually when you've got product market fit because people are excited about it. It's one of those things like porn, you know it when you see it. Like
sure.
My new product market fit framework is like you know it when you have it.
Right.
And when we started testing using video clips of court hearings where we lined up the interaction between the lawyer and the judge, and we put that next to the part in the judgment where the judge decided that point, people's heads exploded. So what we're increasingly trying to do is to think of how can we use transcription and as a way of identifying the most important parts in a hearing that may last 2, 3, 4, 5 days.
So you're talking about the entire story of what happened, not the result.
Not just the result.
You're building the narrative of the entire hearing or the entire process, which is interesting. So the legal research providers, that's interesting now, especially for that's interesting for litigators or barristers, solicitors who are going up to that. You're now talking almost some judicial analytics, aren't you? Potentially. Yeah. Or this person was successful, but why were they successful? And now maybe I can figure this out.
Exactly. Or look, this judge took quite an interesting angle on this case. Let me go back and look at the interventions that she made to try and work out where her mind is on this issue if I'm running something similar. And that I actually been looking at Clear Brief. Have I got that right?
That was just on last week.
Exactly. And the way in which she's talking about how you arrange information to make it much more transparent and being able to have a bundle that you can work your way through and see information side by side and how excited people are at. It's that similar principle.
And she, in her particular thing, was not on the case law, but on the facts of your case that you're using to put together.
Exactly.
Right. And now you're on the other side, the after part of that.
Exactly that.
Yeah, which is interesting. That's very interesting.
So that's and also that people as we're sitting here today, people love video. Video is having its moment. People are very comfortable with perceiving content as video, and there is an intangible that you get by listening to someone.
Yes.
And I spent the last year listening to reams and reams, particularly Supreme Court audio, and there is a moment when you can hear a judge's mind change.
Because you get the tone. It's the tone of the voice.
It's the tone, and actually, so then listening to the way the arguments unfolded.
Yeah.
Before that happens, you can't get from a judgment, and you actually can't get from a transcript. It's too dry. You need to hear that interaction.
Yeah.
As lawyers in court, you feel it.
Yeah.
Right. You know it. You know those tipping points. What you live for. Right.
Yeah. It is the exact thing. It's the exact same idea that people in the US who are concerned about kids and masks, or some people with the masks with COVID, is that they're losing some of the facial cues or the listening cues, which is an interesting idea.
That is an interesting idea.
I'm not being a proponent.
No,
of
sure,
that, yeah. But that impact is kind of interesting, because we do know when I go and I turn on something and I'm now watching what the judge or the jury, or even just something I'm watching entertaining, if I'm watching and listening, I'm getting a different impact, right? And that's what you're saying. We've been able to get the Supreme Court audios for some time. Yeah. But I find that just miserable to even try and listen to. Because it's so slow. But if you had a reason to be listening other than then
Well,
it's a
and
different experience.
what we found is that people get very frustrated easily if they have to listen to the way through. But if it's curated content where
Yeah,
you're taken to the interaction and then you're actually able to listen to it, actually scrub back and forth and be like, actually, I do want to hear the bit before, or I do want to hear the bit after. But you know that the next 3 minutes of your life are going to be worth, or 2 minutes are going to be worth listening to because we've already identified the
that's
bit.
right.
That's the game changer.
That makes a change. That's like that's like us being able to go on the YouTube video and scroll ahead, or put it on 1.5 times or 2 times because I know there's a piece in here I want to hear. I'm not sure where it's at, but I'm going to speed through this stuff. And which I should caution everybody here. You should always listen to every part of this show. It's all riveting. Do not fast forward.
This has been great from the very start.
Yes.
Just make sure you listen to the very start.
Yeah, start at the beginning, listen all the way through. It also helps with the YouTube with how they rank stuff. So do us a favor. But I kid there, but that is an interesting analysis. And you're right with our guest last week, how she's on the side of building that brief. And if you now have the side of what in the brief or what in the argument worked for the judge, that's a lot of data that is now really, really powerful for a litigator.
Exactly. So look, while I am, obsessed with court transcription and like on a mission to be able to do something about that workflow, let me just be clear about it. Like the where this is ultimately headed is being able to sort of revolutionize the principle of open justice. And we're going to do that by making videos more accessible, but also by being able to analyze court hearings en masse.
Yeah, which we've witnessed during COVID when a lot of the court hearings went straight to YouTube, and we all got to do some armchair analysis.
Exactly.
But it's been really important in transparency, hasn't it?
Exactly. And so the US courts have always had a much different approach to open justice, and you've had sort of televisions and courtrooms for a lot longer than we have.
Mm-hmm.
We're much more stuffy. So that there's still a real limit on who gets to see what happens in courts. But actually, there's the parts there's sort of the intangible that you get from watching something. And I think in senior court, so in Court of Appeal and Supreme Court, you do want to see those interactions. But actually, if you want to able to analyze what happened in 200 family law proceedings or 500 or 5,000,
right,
then it's going to change the way in which you understand, the way you think about what changes to bring in, court rules, who's unfairly impacted by legislation, and it radically changes the way in which we're going to think about law reform. So
that's a really interesting point, because that's really where the most, right, we're talking about the high level, the high drama stuff, right? But the day in, day out is where that stuff comes from, right? That's where eventually the Supreme Court hearing comes from one of those 200 cases. So even though it is maybe less exciting or less high drama for the day-to-day thing, that's where the meat and potatoes of the law is being practiced.
Exactly it. And that's where we're all these hearings, increasingly in the UK and I think in the US, all these hearings are recorded. So actually using transcription as a tool to turn those court hearings into data and analyze them en masse. That I think is the tipping point where the sort of the change happens. And,
excuse me.
For us, that again goes to sort of that what happens in a hearing is a public good. It needs to be handled in a way that's safely and securely and thoughtfully. But if it was done in a way that was that we suddenly have sort of unprecedented insights into what's happening in the courts, and would be able to take much more thoughtful decisions about sort of policy changes and rule changes.
So I have to ask you then, it was a year or two ago, I think it was pre-COVID now, maybe it was just last year. I don't know what year it is right now. But this was maybe more relevant to you in the UK than it was in the US, although those of us in legal tech thought it was pretty ridiculous. But in France, there was the judges had a real problem and I forget the exact issue now, but it had to do with judicial analytics, as I recall.
That's right. So interestingly, so I think the sorts of tools that you would access via US Westlaw, which allow you to look at judges' records on particular issues and cases, that's turned off in the UK.
That is okay.
It is, yeah. So there is still quite a lot of reticence.
That's what I was getting at, is how do the judicial officers feel about
in
this?
France, they've criminalized it, which obviously is a
travesty.
Yeah, but you know, there's a balance, isn't there? And I think that it is, you know, what happened when someone walked into court, they don't necessarily think that's going to be public. Now, even though there's this principle that what happens in court is public. If you're the only people in court, you're not thinking
you're not thinking that everybody on YouTube can watch this.
Exactly. It's just not. And the way that you interact with the judge and sorts of information that is a lot of very private, intimate information. And so I think these are issues that all need to be unpicked. But actually that's why sort of we work on these experiences in these two settings. One, which is how can we improve access to legal information for the litigants themselves and for their legal teams to allow them to challenge and not be withheld by the use of high costs. And then looking at the really zoomed out approach, looking at 5,000, 10,000 cases where, you know, you're using anonymized data sets where that someone's private information isn't the bit that you're interested in.
Right.
So those are the things that we're working on.
That's interesting to hear that you guys do have certain stricter privacy controls and rules in UK and Europe than we have here. I think some of us were most offended because it seemed less like, as I recall the story, which may have been written by Richard Tromans of Artificial Lawyer, who is a friend of the show as well, but as I recall the story, it was the judges who had a problem with their privacy being violated in the court. And I think, or at least that was the feeling I got from that in France. And maybe that was lost in translation for me. I don't know.
That may well be right. I think there is a real concern of judges of being considered to be a judge who allows or a judge who refuses. And again, I do get that. You know, I think that is a bit of a Pandora's box. But at the same, again, I think that's, of all the bits of information that you're interested in, there's more interesting things that happens in the courtroom as to how you know, judges who allow reviews. And I think that is a bit of a sort of false horizon.
It felt very, for an open and fair system, it felt very opaque to me from an outside.
This is these interesting things. I think, you know, why has law been held back so much from technology advance? It's like, why are we one of the last industries? You know, I was looking back at your interview with guy who runs Clio, right? And he was like, you know, why is law so slow, been so slow to adopt? And I think there, you know, that we see that in the courts too. If in fact, what's happening in law firms, what's happening in courtrooms is even slower.
I would go as far, Sophie, as to say in the UK, you're still wearing the wigs, which is like, that's an indication. If we're holding on,
I think you guys are jealous.
I am a little jealous.
We look fabulous in those wigs.
but how about that for like holding on to tradition, though, right? Like, it's very indicative of that.
Absolutely, exactly. We're used to our ways of working, and disrupting that does feel very scary. And that's why I said at the start, you know, speech to text, it is ubiquitous technology. The technology is not the complicated part. Keeping it secure is not the complicated part. It's cultural change. It's cultural change. And that's what the main thing that our social enterprise is trying to do, is slowly to shift that needle to try and encourage people to see this technology is not something to be nervous about, that it has the power to transform. And also me trying to pretend that transcription is sexy.
You've done a very good job of that tonight, I think. This has been a great interview. I know we're now 45 minutes in. I want you to go back to bed before the sun comes up. Tell everybody how they can find you on, because I went to Just Transcription, which redirects, and there's a different, more of a overhead website. So what's the best website?
So if you head to Just Access, so that's www.just-access.org, and that takes you to our website. I'll put on that on Twitter and LinkedIn as well. And if you just click our Get Started, our call to action button, our Get Started, I'll take you straight through to our transcription engine. And we're keen for people to, like all technology providers, all we want is feedback.
Right.
So please have a go. Let us know what you think. We provide edited services, we provide captioning, while we work on our sort of big, hairy goals of dragging open justice into the 21st century.
Excellent. So that's just JUST-access, ACCESS.org. My guest tonight was Sophie Walker. She is the CEO. And is Just Transcription just a subset of Just Access?
That's it. Yeah.
Yeah, it is. Okay. I just want to make sure I got that. But how do they, on Twitter, it's at Speech to Justice. And are you on Appellate Twitter, or are you available on Twitter? Or are you?
Yeah, absolutely. That's us. That's the Twitter handle.
That's the Twitter handle for you. Yeah. Okay, perfect. And so if you're interested in this, please reach out to Sophie. Sophie, thank you for being here tonight. Don't disappear when we stop recording. I got something to share with you. But thank you for being here. Thank you for waking up early in the morning to do this.
I've loved this, Nick. Thank you.
Thank you.
I always had a bit of trepidation, but this has been really fun. So
good. I'm glad. Thanks so much. Folks, stick around. Next week, we'll be back with Kristen and Talitha of Law Clerk as we keeping on with our Female Founder series. So stick around for that, or come back next week for that. And Karen will be up in 2 weeks. Karen will be with us 2 weeks from now, which I assume is why she's watching here tonight. But thank you, Karen, for being here. Sophie, thanks again, and you have a wonderful night.
Thank you very much.
A wonderful morning.
I'm going to go to bed now.
You go to bed now.